SJC-12933 in the matter of an impounded case.
Good morning, Chief Justice, honorable justices of the Supreme Judicial Court. Before I begin my argument, I just want to let the court know that although I live in the most rural part of the state, God blessed us yesterday morning with broadband. So I'm hoping that we have no problems during this. And my heart goes out to the attorney who was arguing before me. I feel very bad for her. Drawing attention to the case, my client, John Doe, was 17 years old in 1993 when he pleaded guilty to a sex offense in the district court. This was before SORB existed, before the sex offender registry laws. 10 years later, he accepted a level 2. At that time, there was no internet dissemination of level 2s. And in 2018, the board sought to upwardly reclassify him from 2 to 3 based on the commission of new sex offenses and the fact he was incarcerated.
Okay, can I interrupt you for 1 minute and then I'll let you get back to, I just want to clarify a couple things in light of your letter yesterday or the day before. So what issue 2, which is, issue 1, which deals with the question of the standard, whether it's clear and convincing evidence or whether it's by preponderance of the evidence. Are you saying now that the hearing examiner used the right standard or the standard you're advocating throughout the whole proceeding or just in certain places?
So there were 2 hearings. The hearing examiner in 2016 used the preponderance standard, but the case was remanded by the Superior Court so that the hearing examiner could consider the trial transcripts. Then the second hearing examiner, for which this case is on appeal, did apply clear and convincing, but then the Superior Court judge on judicial review applied the preponderance standard. We argue, of course, it should be the clear and convincing evidence standard. Although our argument in issue 2, which argues the application, doesn't depend on the standard. We feel that regardless of how the court decides issue 1, whether it should be clear and convincing or preponderance, that we should prevail. In terms of issue 1,
Can I ask one question on the standard? The Superior Court, did he apply the clear and convincing evidence to the entire issue and preponderance to the conviction? Did he just apply preponderance of evidence to the upward determination itself? Because they're 2 different issues, right? Whether this subsidiary finding, whether he committed the sexual assault, was by a preponderance of the evidence. But he could have found that by the preponderance of the evidence, but the overall thing by the overall upward, change upward by clear and convincing. I just want to make sure I understand what you say when the Superior Court applied preponderance. Where did he apply preponderance to?
So the board applied clear and convincing both to risk of reoffense and degree of dangerousness and to the existence of the new offense, while the Superior Court applied clear and convincing to the risk of reoffense and degree of dangerousness, but preponderance of the evidence to the event triggering reclassification. Regarding the standard of proof, we essentially have 2 arguments. We concede that the cases cited by the judge do indicate that in administrative hearings, preponderance is typically the standard for subsidiary facts. However, we argue 2 things. Number 1, SORB hearings aren't like administrative hearings in other contexts, and this court has declared that individuals before the board are afforded due process rights and protections that go above and beyond. And secondly, is the question between a subsidiary fact and an ultimate fact. A subsidiary fact is like an ingredient. You put ingredients together like the factors that the board considers, but ultimately the board has to find risk of reoffense and degree of dangerousness by clear and convincing evidence. However, the factors, the ingredients, are only by preponderance. We feel that the fact of the new offense is not a subsidiary fact. It's not an ingredient. It's actually a legal fact that the board must decide by a certain standard in order to trigger reclassification in the first place. So we argue that basically for two reasons we should prevail on issue one. Number one is that sex offenders before the board have liberty interests that go above and beyond the average person before an administrative board. And two, that this is not an ingredient. It's not a subsidiary fact that's combined with other facts to reach a legal conclusion. The board, in order to upwardly reclassify somebody under 803 CMR 1.32, must first find that they did commit a new sex offense. So
But isn't this a little more complicated than that? Because we've got also all of his other offenses. They're not sex offenses, but we have other criminal behavior, right? So this wasn't a case where the upward reclassification was only based on the new sex offense issue, but it may have been based on multi-parts. I understand one of your arguments is that it was only based on that, but don't we have to divide this up a little bit?
Well, the rule that the board promulgated in response to legislative changes on upward board-initiated reclassifications requires the board to do a vote. And they have to put in writing the basis for the upward reclassification attempt, the petition, and they need to have a majority of the board. And they did that in March of 2018, and the two bases for the upward reclassification petition was the new sex offense and that the Mr. Doe had spent 60 days in the House of Corrections. So although Mr. Doe does have a myriad non-sex offenses from 1993 to the present, that wasn't the basis for the upward reclassification. The basis for the upward reclassification was the 2015 sex offenses that resulted in acquittals twice, as well as the drug and larceny case. My brother in his brief cites the fact that the board vote isn't specific on which incarceration resulted in the petition to upwardly reclassify. However, in argument 4, in issue 4, we argue the statute and the rules require that the information be new. We have a petition from March of 2018. So the information that is used for an upward reclassification by statute needs to be new. And the only incarceration that is new was the 9-month incarceration on the drug offense. Yes, Mr. Doe was incarcerated for 2 years in 2008. However, the board, we would argue, cannot seek to reclassify somebody in 2018 simply based on an incarceration from 10 years prior. Focusing further on issue 4, we have a case where the board became aware of a new sex offense in 2015, and they attempted to reclassify, but they didn't follow the proper procedures. And in February of 2018, the petition to reclassify was dismissed. So in February of 2018, everything that happened between 2015 and 2018, which was the reclassification hearing, going to the Superior Court, the remand, none of that has legal import because that case was dismissed. The case before this court commenced in March, April of 2018, and we're talking about the board reclassifying an offender based on very old facts. The sex offense, the acquittal was in 2016, and the board cites myriad things that happened in many instances a decade prior to the reclassification efforts. So in essence, issue 2, we could argue all day. There's 2 full transcripts. There were 2 jury trials. Mr. Doe was acquitted twice. I'd simply point out that at the first hearing, there were no transcripts. The hearing examiner found by preponderance, based solely on the police report, uncross-examined. But at the 2 trials, I'd asked this court to focus on the evidence introduced at those trials that really undercut. I mean, the lieutenant, the officer, the Honey Farms employee, the first complaint witness, and Eric, the eyewitness, they all undercut the allegations. We believe, notwithstanding this court's determination, and we realize that this court has taken this case on direct appellate review, sua sponte, to address issue 1, which is the standard clear and convincing versus preponderance. But in our experience, is there really a difference in how the board applies the standard? We don't really have evidence that the clear and convincing versus preponderant standard in these cases would really be dispositive. But regardless of the standard, we'd ask the court to read the transcripts and our argument and look at all of the pieces of evidence that undermine the Commonwealth's case. If there are no further questions, Mr. Doe would rest on his brief.
Okay, great. Thank you.
Thank you.
Mr. Chanel.
Couldn't find the unmute button. Sorry about that. At my age, technology gets harder and harder. If it pleases the court, Chief Justice Budd and your honors, David Shanai for the board, I think you have to get right to the heart of the matter of, I really think this comes down to what kind of information the board should be able to use to reclassify or bring an upward reclassification. I think you have to look at the process and say, there's two factors here. One is the beginning, which is the investigative process, and then the second, which is the adjudication process. And in the investigative process, really the board should be required to have reliable information that indicates an individual's risk and danger is elevated or has elevated or could possibly have been elevated since their reclassification. And the reason I say that is because at that initial stage, there is no jeopardy attached to the individual. And the board has the mandate to protect the public against dangerous sex offenders. Now, in this situation, it's kind of like a probation violation issue. The individual is already part of the, or is within the jurisdiction of the board. And the board has already indicated from the first classification that the individual poses at least some risk and some danger, either it's a 1 or a 2. And the whole idea of the reclassification is if the board gets information, and I would say reliable information, because the information they get comes from agencies, district attorney's office, police departments, correction officers. It doesn't, the board itself doesn't seek out the information. We don't have investigators. We don't track people on a daily basis like probation does. But because no jeopardy attaches when we start the investigation, what we're looking for is just the reliable information that would indicate a risk. And if you look at the statute,
don't you have to give him some notice of what you're going to base it on, right? I mean, there's a due process issue with that. So if you change direction, don't you have to inform him of that?
Well, that's how the due process is set up in this situation. When we decide that we're getting information that an individual might be escalating or his risk or danger might be elevating, we notify the individual what we're considering, that we're considering an upward classification based on things that we're seeing. We tell them what they are, and we give them time to send in information to refute that. Then the second stage is after we give them that time and opportunity, and after reviewing anything that the offender sends to us, we then send out to them our recommendation and we say we're going to upward classify you.
Let's get specific here then. The notice had two bases, right? The new sex offense charges and the 60 days of incarceration. Is that
correct?
And were those the basis for the upward classification or not?
Yes.
So the notice, and so this issue you're talking about doesn't matter here because the notice and the basis were the same?
Correct.
Okay, so now can we get to the issues we've got to decide, which is if you've got a new charge of a sex offense, okay, there's acquittal on it. Do you have to prove, does it have to be proved by a preponderance or by clear and convincing evidence when there are multiple prongs to the I take it if it's the sole change, that has to be by clear and convincing evidence, or is that not true?
No, I think what we're doing is we're blurring blurring it a little bit. Again, in the investigative process, when we bring the action, just because someone has been incarcerated more than 60 days doesn't necessarily mean their risk or danger has gone up. Just because someone is being investigated for a sex offense doesn't necessarily mean that their risk or danger has been risen. That's why we have the adjudicatory process where they actually get to have a hearing and contest the board's recommendation. At the hearing is where you make the determination by clear and convincing evidence if in fact the individual's risk or danger had actually increased. In this case, the hearing examiner found that it had increased.
So
Again, that's where due process comes in.
Just
The
to be
hearing,
specific, because we've got to, do you have to prove in Mr. Gautier's language, you know, the effect, I don't want to use this ingredients thing because I find it confusing, but do you have to prove the individual conviction here, the individual sex offense, you have to, the level of proof for that to be meaningful, is it preponderance of evidence or is it clear and convincing evidence for the new sex offense?
okay, and again, I just want to be clear. The initial investigation isn't based on a standard such as preponderance of the evidence or clear and convincing. It's after we go to the next stage when the individual requests a hearing to contest our recommendation. At that point, the hearing examiner the board has to prove by clear and convincing evidence that the individual's risk and danger has elevated enough to upward reclassify that individual.
Right.
So,
so
it's just like a classification hearing.
I get the big picture issue, but it's an analogy that you may not be familiar with. In DCF cases, the individual incidents are proved by a preponderance of the evidence, but the overall determination is by clear and convincing evidence. I'm trying to understand here what level of proof we have to have for that new sex charge to be considered relevant. Does the Commonwealth need to prove that by a preponderance of the evidence, or does that individual new charge have to meet the clear and convincing evidence standard because it's so important to this determination?
No, because it's a subsidiary fact, it's by preponderance of the evidence. And I cite In re Laura as a case, and in Doe 496501, I think we also, this court said that in board cases that the subsidiary facts, which the new sex offense would be, is by a preponderance of the evidence. That's what the board has to find that it happened. It's making the final determination whether or not that, with all the other evidence, by clear and convincing evidence, raises to the level of an upward classification or an elevation in the risk and danger. But the actual subsidiary findings are by a preponderance of the evidence.
Okay, so in this case, help us out here, because he got a level 2 before, so we got to look at new stuff, right? We should only be considering new stuff if we're going to go up, right?
Correct.
So what is the new stuff here that makes it go up to 3?
The new stuff here is that, and it's not new as in just 10 days ago or a year ago. It is new. The word new is used because it begins from any information since the original classification. Mm-hmm. Now, this individual on 8 different occasions was incarcerated for more than 60 days. That became part of it. Once the hearing was scheduled, we had not only the new sex offense allegations and the evidence of that, but we could also now consider all of his criminal behavior since his last classification or his original classification. So bringing all of that in is part of why his risk was elevated at that point, because some of these crimes were serious crimes. Now, looking at the actual sex offense, that was just one component of the ultimate decision. And again, we didn't have to prove that the sex offense, we only had to show a preponderance of the evidence that it occurred and that it was reliable information that it occurred. Now, I think we have cases where you say, just because someone was not convicted of an offense, that the board still had the right to consider that offense. I think the So case says that, and I believe Doe 523391 says that. Even if you are basing information on a case where it ultimately results in a not guilty, the board can still consider that case if they have reliable information that shows by a preponderance of the evidence that the events alleged in the facts occurred. So the board has the right to look at those type of things. Just because this individual is found not guilty of the ultimate sex offense did not prevent the board from considering it, because we're looking at it as a preponderance of the evidence. Another case that's close to this is Doe 52252997, which was in 2013, where this court specifically said the board can consider during a classification process pending criminal cases, and that the individual does not have a right to a continuance of a SORB classification hearing just because he has a pending criminal action. And therefore, the board could go forward with that process. Now, so based on that information, even with this case, even while this case was pending, this new sex offense, the board had the right to go forward and determine whether or not the evidence produced showed by preponderance of the evidence that this individual had committed this event based on reliable information. Now, again, the due process rights are protected because the individual had the right to come in and argue against that, present evidence against that. He also had judicial review of that, and he gets appellate review as the fact that we're here today on it. So there are procedural due process put in position in these circumstances. But ultimately, and that's the adjudicative process, we only have to show the subsidiary findings by a preponderance of the evidence.
And when we review, I'm just trying to understand what we do on this, so that you find by a preponderance of the evidence that this sex offense was occurred. Do we owe you any deference on that? Because you're looking at the criminal trial transcripts, or do we have to do that de novo ourselves? How does that work?
Well, you have to give deference to the hearing examiner's decision, unless you find that the factual decisions made by, or factual findings made by the hearing examiner were either arbitrary and capricious or contrary to law. But if you find that that the findings are reasonable, then you have to give deference to the board. The board is the ultimate fact finder. If, again, you decide that the factual findings were contrary to law or arbitrary and capricious, then as just as the Superior Court would have the power, you even probably have more power, being the Supreme Court, could alter the decision on that level. But that's why we have judicial review of these hearings, so that the the offender has the ability to allow the court system to make sure that the hearing examiner made the proper determination based on the fact pattern that was before it. But again, there is a deference to the hearing examiner's findings of fact and law on these issues.
Although I'm confused a little bit. We normally would look at individual facts to see whether they're clearly erroneous. Is that, but because we've got this the key finding here, right, is the new sex offense. That's a key finding, right?
Correct.
And you have to you say the SORB does this by the preponderance of the evidence. We also have the exact same evidence you have on that trial, right?
Correct.
We normally don't give any deference on documents. So I don't know how that works here. So we normally find facts by we normally respect facts unless they're clearly erroneous, but at the same time, we're sort of doing a de novo review of that of that preponderance of evidence finding. That's a little tricky. Yeah. It's a question. Is it?
Oh,
or am I wrong and there's something simple here? That would be helpful.
No, I think, again, case law says that the deference should be given to the hearing examiner's decision unless you find it either clearly erroneous or you find that it's arbitrary and capricious, which is essentially the same thing. If you find that, you have the right to alter that decision-making process. But that, again, it doesn't undermine the board's initial ability to bring the action, and it doesn't undermine their ability to determine facts by a preponderance of the evidence. The only difference is that you're saying, and again, minds can disagree as to whether or not that actual findings of fact was reasonably made. If you find it wasn't reasonably made, and that's why we have judicial review of these cases, then you can act on that. So I'm not saying that you cannot say, okay, in this case, the board clearly erred. That's your call. What I'm saying is that it still doesn't prevent us in the future from looking at these cases through the lens of a preponderance of the evidence for the subsidiary findings like we do in every case. Because keep in mind, these individuals have already been classified. They are subject to the board's regulations. So these new hearings are to determine whether or not there is a showing that there's an elevation of risk and danger. We have to prove that by clear and convincing evidence, but the underlying facts to get to that point are still by a preponderance of the evidence.
Anyone have any further questions? Okay, thank you very much, counsel.
Thank you.